microphone is still muted. Sometimes I think you have to go into the permissions setting.
Oh, how's that?
Perfect.
All right, ready to go.
Thanks so much for joining me. Okay, so we got a couple people, maybe a couple more have come in. I know this is a pretty esoteric topic. So just by way of background, for those of you who don't know me, I'm a patent attorney with 20 years of patent, largely litigation, transactional, but also some prosecution experience, mostly in the pharmaceutical, biotechnology, medical device space. I've done litigation in court and in arbitration, which are the two, and at the patent office, which are the three different forums in which we'll be talking about today. Gaston, you mind introducing yourself as well?
Sure. Hello, everybody. My name is Gaston Krug. Like Dan, I'm a patent attorney. I've been litigating patent cases, including pharma and biotech, since 2002. Coming up on 20 years myself. I'm a founding partner of Marketing Advisors, which specializes in bridging the gap between the investment community and ongoing patent litigation situations of interest. We've known Dan for a long time, and I'm really very pleased to be able to do this with him. So looking forward to the discussion.
Yeah, thanks again for joining me. So just to give everyone an overview, these disputes, which I'm sure most of the people who are listening already know, relate to antibody drug conjugates, which are a new kind of, I call them heat-seeking or heat-guided missiles for chemotherapy drugs, where the ADC is made up of an antibody and a drug, and then there's a linker that connects the antibody to the drug. And the theory is the antibody finds exactly the cells or the tumors that want to be targeted with the drug. The drugs used with ADCs are generally too toxic to just be taken generally. That's why they have to be attached to these antibodies, which kind of seek. And once the antibody finds the target, then the drug gets released into the target. And one of the most critical parts of this technology is the linker that links the antibody to the drug. If that linker's too weak and you take the drug could be released into your bloodstream or otherwise, and not specifically at the place where you want to target. So ADC, the linker technology, has been something that Seagen has focused on for a very long time, 20 some years. And they entered into a collaboration agreement with Daiichi back in 2008. And the collaboration agreement was intended to have the two parties work together to see how they could use ADCs to make great drugs. That relationship ended a few years ago, and under that contract, one of the terms says that if Daiichi comes up with an improvement to Seagen's linker technology, then any improvements that Daiichi comes up with will be owned by Seagen, but still be licensed under the agreement, and Daiichi will have to pay a royalty. So the first dispute that arose in the summer of 2019, so we're talking just a little bit over 2 years ago, was when Seagen noticed or recognized that Daiichi had come out with its own ADC drug, and now known as Enhertu, but they have some other drugs as well. And Seagen said, hey, wait a minute, the linkers that Seagen is using, those relate to the linkers that we showed them we had, and thus are subject to the agreement. And there's letters that go back and forth. All these materials are publicly available, and Gaston or I are happy to share them with anyone who'd like to know. Some letters went back and forth, discussions happened. The parties couldn't come to an agreement about whether or not this improvement, whether or not Daiichi's linker in its new drug Enhertu is an improvement, quote unquote, under the contract and thus to be owned by Seagen. Daiichi obviously disagrees with that. Daiichi filed its lawsuit in federal court under the Declaratory Judgment Act, saying we want a declaration from a judge, we haven't done anything wrong, that our linker is not owned by Seagen. Within a week, Seagen filed a demand for arbitration because the collaboration agreement has a mandatory arbitration clause. The district court judge allowed the arbitrator to decide whether or not this was a dispute subject to arbitration. The arbitrator decided it was. That arbitration took place in June, and now we're waiting for a decision. In the meantime, there's been a patent infringement case filed by Seagen, and I'll let Gaston go into that.
Thanks, Dan. Yeah, so just to orient everybody on where things stand on the patent infringement side, Seagen is asserting a single patent against Enhertu. It started with a lawsuit that they filed in October of 2020 in the Eastern District of Texas, which is a very popular place for patent infringement lawsuits. A few weeks later, on November 13th, 2020, Daiichi filed its countersuit in the District of Delaware, seeking a declaratory judgment that they don't infringe on the patents. And then just to wrap up the kind of sequence of events, in December and then following in January, Daiichi filed what are called PGRs, post-grant reviews, in the patent office, asking for the patent office to take another look at the patent that Seagen was asserting against it. In the Eastern District of Texas case, Daiichi moved to dismiss the case, arguing a number of things, including the fact that Seagen had literally filed the case too early, because Seagen did file the case within minutes of the patent being issued, and because of it was actually an interesting argument around the time zone difference between Texas and the East Coast, whether or not Seagen actually had the right to file the case at the time that it did. They also tried to move the case out of Texas, which is considered a more plaintiff-friendly jurisdiction, to Delaware. That motion was denied by the judge in Texas, and the attempt to move the case to Delaware was kind of thwarted. At the same time, in the Delaware case, Seagen moved to stay the case in Delaware, saying, "Hey, judge, we already have a case on this same patent that's moving forward in Texas. There's no reason to duplicate the work." In April of this year, the judge in Delaware said, "Yes, I will stay the case." And that stay has been extended till at least November 5th of this year. Turning back to Texas, there was recently a Markman hearing, or claim construction hearing, which is a critical step in any patent infringement case. It's the point in time at which the district court judge has the opportunity to construe the disputed terms and the patent claims at issue. That's a question of law for the court that ultimately gets reviewed down the road on appeal if this case continues to go forward. So that process is fully submitted, and as Dan can speak to after I wrap up this introduction, every indication is that the judge has said that he will address the Markman decision quickly. Finally, to close the loop in the patent office, Daiichi's attempts to have the patent reviewed by the patent office were rejected by the judges in the patent office. The theory was that under a new set of discretionary tools, and it's called the Fintiv case, the argument is that the patent office wouldn't be able to reach a final decision in the post-grant reviews that were filed before the Texas court finishes its work. And as a result, there's no reason to duplicate efforts, and you want to move the patent office process to the side and let the district court finish. And that's a discretionary decision that was made by the patent office with respect to Daiichi's attempts to get the patent office to do a second review. That's currently on what we call a rehearing request. Daiichi is trying to argue that that the patent office got it wrong, that these discretionary denials were never intended to apply to post grant reviews, which are limited to newly issued patents. But that's still in process. Personally, I don't think there's much hope there of the patent office revisiting this question at this point. So, kind of to sum it up, you have Seagen, filing a lawsuit, obviously seeking a royalty, and in the pharma context, royalties with respect to blockbuster drugs can be very sizable. Daiichi has tried to expand the front, try to move the case to Delaware, try to file cases in the patent office. So far, none of that has been successful. But I think, and I'll turn it back to Dale with this, I think it's important for everybody to realize that we're still in very early stages of the, general patent infringement dispute between the parties, though the next step in evaluation of where we are is going to be once we get the court's Markman decision. So maybe, Dan, you want to kind of address what that might look like.
Yeah, sure thing. So I just want to make sure at a very high level, people don't conflate the arbitration with the district court case in Texas, because they involve completely different patents. So just to start from the very beginning again, Seagen originally applied for its patents going back to 2003. So 2003 is when Seagen first started applying for patents. The patent that's currently being asserted in Texas, it wasn't granted until 2020. And Gaston and I can buy everyone a beer and explain to you why a patent that originally claims priority in 2003 could still be granted in 2020, but just take it, that's how our system works. Now that patent will expire in 2024. So even though it was just issued in 2020, it'll expire in 4 years. That is Seagen's patent. No one disputes that Seagen owns that patent. Then in 2008 is when the collaboration agreement was entered into. Then in 2013 is when Daiichi started filing its own patent applications for ADCs. Then in 2015 is when the collaboration relationship ended. And then in 2019 is when Seagen notified Daiichi that it believes the patents Daiichi started applying for in 2013 are covered by the collaboration agreement and thus are to be owned by Seagen. The answer on that question, whether Daiichi, the patents that are currently owned by Daiichi should be owned by Seagen, is a decision that the arbitrator will make. The hearing took place in June. Arbitration is inherently secretive. We don't know what's going on. We don't know what evidence may have been unearthed. We don't know. There might be an extremely inflammatory email by Daiichi CEO saying, let's rip off Seagen. There might be an inflammatory email by Seagen CEO saying, let's try to pretend that Daiichi's invention is ours, even though I recognize it's something completely different than what we did. Who knows what evidence there is? Who knows what arguments there are? We don't know. That's one of the reasons why companies like to do arbitration, because it keeps all this kind of information confidential. My expectation is that hearing probably took a couple weeks in June. It wasn't a one-day thing. It likely was a couple weeks. The parties likely were asked to file post-hearing briefing, which probably took place July and August. Maybe it's finishing up as we speak. And then once that post-hearing briefing is done, the judge will take a couple months to issue his opinion, or the arbitrator. He's a retired federal judge who had 20 plus years of experience in New Jersey. So he's a very competent, very experienced arbitrator who will be making the decision. We really have no more insight than that, other than what the initial arguments were made in the public filings by the parties about why they do or do not believe that Daiichi's linker is a quote-unquote improvement, as that word is defined, under the collaboration agreement. So then going back to the litigation, which is then the patent litigation, which was filed in 2020, even though the arbitration had already been ongoing for almost a year, we've got that Markman hearing that Gaston just explained. And the purpose of a Markman hearing, as far as a defendant is concerned, is to try to get the patent interpreted in a way which provides the defendant an easy argument for either non-infringement or invalidity. And most of the time it's non-infringement because the burden of infringement relies on the plaintiff, or Seagen in this case. So, for example, one of the main disputes they're having in the claim construction hearing is whether or not Seagen's patent that was issued in 2020 but derives from an application filed in 2003 is whether or not it's limited to a specific type of ADC or whether or not it's broader and applies to a class or generically ADCs in general. That question isn't on its face outcome determinative. But if the judge was to say, you know what, I agree with Daiichi that this 039 patent issued to Seagen in 2020 that dates back to 2003 is only limited on a very specific kind of linker, then that gives Daiichi a layup in saying, look, we don't have this particular kind of linker. We don't use it, and there's no argument that we do, and so we don't infringe the patent even if it is valid. So we'll have to wait and see what the judge decides on those claim construction arguments. One of the cool things about litigation as compared to arbitration is we get to see a lot of the filings, including the exact PowerPoint slides that the parties used during the hearing on claim construction a couple of weeks ago. So, Gaston, what thoughts do you have about what you think might happen going forward?
Sure. So, I want to harken back to my kind of characterization of East Texas as a plaintiff-friendly forum. And there's a lot of debate about, to what extent that's true. But I think, it's obvious in this situation that when Seagen decided where to file the case, they filed it in the Eastern District of Texas. And I think what they're banking on is that by filing in that jurisdiction, they have the best chance possible of getting this case to trial. And I think the trial date is in 2022. Post Markman hearing, you may see some summary judgment briefing where the parties make arguments based on whatever the judge actually decides. But if you're in Seagen's position and you have this lever of kind of a unstoppable freight train to trial in the Eastern District of Texas, that's really the best you can hope for as a patent plaintiff nowadays. And that doesn't matter if you're asserting a pharmaceutical patent or a consumer products patent or anything else. I think the trick for Seagen is to continue to fend off, these attempts by Daiichi to, push the focus of the case outside of Eastern District of Texas, and really see, what else it can do on Seagen's side to try to get Daiichi to agree to a settlement, ideally before trial or even, at trial itself. Ultimately, in a patent case, the longer it goes on, the more things tend to favor the defendant, particularly when you start talking about appeals processes in the federal circuit and the likelihood of, sustaining a jury verdict. I think thinking long-term about this case, Seagen's focus should be make sure that trial date stays as firm as possible and see what levers it could pull to try to get Daiichi to agree to a settlement, rather than find yourself in litigation for another 3 or 4 years, where Daiichi has, plenty of arguments it can make, particularly on appeal, to try to, reduce the value of the patent or maybe get it invalidated, as we've seen in other biotech situations.
Yeah, this does come down to money. No one's contemplating Enhertu being pulled from the market. This is just about whether or not Seagen is going to be entitled to a royalty, either based on its own patent that expires in 2024, or if it is declared the owner of the Daiichi patents, which date back, I went back and just confirmed it is 2012. I was right the first time. They filed their Japanese application in 2012, their first US application in 2013. If Seagen is declared by the arbitrator to be the owner of the Daiichi patents, well, those last until 2033. So we're talking almost another 9 years. Now, what would they be entitled to? A royalty. The patent damages statute says when you're the owner of a patent and it's being infringed without your permission, you're entitled to the greater of either your lost profits if you have a substitutable product to which you are or of which you are losing sales to the infringer. If you don't have lost profits, then you're entitled to a reasonable royalty, which is what a willing licensor and a willing licensee would have agreed ex ante or in advance. And here we know what the answer to that question is, because there is exactly a patent license agreement which has a royalty rate between the parties for patents that Daiichi creates or gets that should be owned by Seagen because they relate to improvements under the arbitration. So now those royalty numbers are redacted from the public versions of the documents, but I'm sure probably people that are smarter than me can go and maybe figure out, looking at the accounting that Seagen did of its revenue from the relevant time period, maybe what some royalties is. Who knows? I don't know if that's possible. But at the end of the day here,
let me jump in there, Dan. I mean, I think it's good context for people to understand that one of the fun things about what I call these royalty plays in the pharma patent space, right, where you have a patent owner that's targeting a blockbuster drug, looking to get royalties. One of the interesting things about the pharma space, as kind of contrasting with consumer products or other types of technology areas, is that the royalty rates in pharma can be really high. For example, there was a case that just went to the federal circuit where at trial the verdict was for over $1 billion total. The royalty rate was 27.6% on sales going forward. Ultimately, in that particular case, the patent was invalidated by the federal circuit. Hence my point before about trying to lock in your gains via settlement rather than risk the litigation all the way to the end. But even if one were to argue, as Daiichi might, that the royalty rates in the patent license agreement between Seagen and Daiichi are not necessarily indicative of what Seagen would have accepted for the rights to this particular 039 patent, just as a matter of general context, I think it's important for listeners to understand that the royalty rates in these pharma royalty play situations can be really high, and they've been endorsed by the federal circuit in other cases as well. So the federal circuit understands that in this type of context, if you have a patent to, like, the linker in this particular case, and that is what allows Enhertu to work or to be marketed and sold and earn what it does, the amount of potential revenue for Seagen is significant, even though the patent itself may only have a few years left.
Yeah, great point. The royalties awarded in pharma biotech are definitely different than those awarded in like cell phone cases, or where there's thousands or tens of thousands of patented inventions that could be relevant. I mean, going back to what we said at the beginning, the most important part of an ADC is the linker. Antibodies are pretty much well known. Really toxic chemotherapy drugs are well known. They're just on the shelf because they're too toxic to take. It's this linker that's really the sweet spot, the important, the beef of the hamburger, if you will, to use a bad analogy. So, and yet just one more point. So when you have district court patent litigation, like the case in Texas over the 039 patent, Gaston and I completely agree that that's a long, winding story, and it'll go to the federal circuit, and that could take years, and once in a while, cases even go to the Supreme Court. Arbitration, completely different. One of the things about arbitration, in addition to being completely secretive, is that there's almost zero chance of appeal or any change by a court. It is possible for a party that loses an arbitration to run to the court and say, Your Honor, that arbitrator ruled against us because they were paid off or they were biased or they just made a really, really bad decision. But attempts to reverse an arbitrator's decision fail 99.99% of the time. So whatever the arbitrator decides about whether or not the Daiichi patents that last till 2033 are owned by Seagen or not, that decision's pretty much going to be final, and there's not any chance of it being disturbed. Whereas the decisions of the district court judge regarding the 039 patent that expires in 2024, that no one disputes is owned by Seagen, those decisions can, especially when it comes to damages, be subject to a lot of change on appeal. So, Gaston, we've got 2 minutes left. We wanted to wrap this up by 11:30. First of all, thanks again for spending the time here. Any final thoughts or comments you'd like to share before we say goodbye to everybody?
I first of all, thank you for inviting me. It's been great. I hope we have a chance to do more of these on this case and other cases going forward. I think again, the key to these situations is a constant reevaluation of what's going on, and part of that will be, keeping an eye on the arbitration decision when it comes out, keeping an eye on the patent office to see if Daiichi's petition for rehearing is somehow taken up, and then keeping an eye on both the Delaware and Texas cases just to make sure that the status quo is preserved. But ultimately, I think Seagen's in a race to get to their trial date or somehow force Daiichi to the settlement table, and I'm very interested to see how it plays out. So thanks again, Dan, and this was a lot of fun.
Great. Yeah. And if anybody has questions, follow up, or want to see some of the documents we referred to, feel free to send Gaston or I an email or a DM. Hope everyone has a great day. And yeah, definitely, Gaston, let's plan to do this again. Thanks so much.
All right. Thanks, everybody. Have a great day.
Bye.
Bye.